Afternoon, everyone. Paul Henderson here, Liberty University, Business 343, Professor Aaron Lockhart. The topic today is grievance discussion, case number 6, which highlights work requirements for holiday pay. An introduction to our case begins with union truck driver John Arnett for Saga Food Services. Now, John is scheduled typically Tuesday through Friday and works 4 10-hour shifts each day. The case picks up with it is a holiday week. Labor Day falls on a Monday, which is not a typical day that John works. However, historical practices with the company allows drivers to observe holidays that fall on an off day to be observed on the very next workday, which in this case would be a Tuesday. John then took on Tuesday evening, 11 p.m., called in and decided he wanted to take a personal leave day for Wednesday. My role with this in case is I'm the Director of Human Resources. My point that I would like to discuss with this is that John did not, in fact, fulfill the requirements of the collective bargaining agreement. Subsequently, John was denied his holiday pay. In response to my denying John his holiday pay, Teamsters Local 444, in fact, filed a grievance on behalf of John. Now, moving forward to the main points of this case, we would have to determine if the company was justified in withholding John's holiday pay. We would also have to examine historical precedent, both at the company level and at the federal and state levels for holiday pay policies and personal leave days as well. And most importantly, since this is a union organization, a collective bargaining agreement exists, we would have to review Article 7, Section 703 of that collective bargaining agreement, which discusses holiday pay allowances and the company's responsibilities. Now, the points and issues, let's begin with the indisputable. Indisputably that the holiday did in fact fall on Monday, which historically they were permitted to be observed on Tuesdays, which John did in fact do. A separate issue or separate circumstance would be the personal leave day. John was compliant. He did give an hour-and-a-half notice on to take his personal leave day, and that was accepted. Now, the reason for denying the holiday pay was based on the collective bargaining agreement. John or any employee to be paid for the holiday would have to have had worked the day following a holiday unless there was a workplace injury or a sickness, which John did not have. The individual would have had to have received prior authorization from the supervisor, which John did not do. And so basically John did not fulfill the collective bargaining agreement by showing up for work. My supporting the research in determining this would, let's begin at collective bargaining agreement aside, let's look at the facts. The Fair Labor Standard Act does not require any company to require payment for time that's not worked, like vacations or holidays. Also, the federal law and state laws do not require companies to pay non-exempt hourly employees for time that such as holiday time that they do not in fact work, but they are required to pay non-exempt salaried employees for this. Now, John was a non-exempt employee. Also, looking at Pennsylvania state law, Harding versus Duquesne Light, does not create a right to wages or benefits for an individual, but if these are afforded to an individual, they must be detailed at the time of hire what those wages and benefits are, but also provide a remedy when that contract is breached. Which leads us up to we have a contract in place with the collective bargaining agreement under Article 7, Section 7-03, which is holiday pay allowances, will be given subject to the following terms and conditions. The employee shall have worked his full scheduled workday immediately before and immediately after the holiday, except for proven sickness or injury. The shift manager may offer to waive this rule in advance of the holiday, and acceptance thereof by an employee or employees shall be on seniority basis. So that said, my plan of action for John is that John will be paid for his personal leave day on Wednesday, and we will also permit John to take an additional personal leave day if he has them in his available to him for the Tuesday holiday observance, which he did not work. In conclusion, stipulations for paid holidays and time is clearly communicated in the collective bargaining agreement. John did not fulfill the collective bargaining agreement and was subsequently penalized by being denied holiday pay. An alternative conclusion to this, John could have, he could have received prior authorization from a supervisor to take that personal leave day after the holiday. He could have obtained a sick note from a physician. Had John, in fact, been sustained a workplace injury, this would not be a factor. Also, if he would have simply just shown up for his designated shift, John would have received his holiday pay. Thank you. God bless you. Have a great evening.